Hello, welcome to our session about navigating a tech layoff. We're just going to give it a couple of minutes for folks to join. Thank you to everyone who's joined so far. Again, thank you to folks who are joining. We'll get started in just a moment. Okay, all right. Thank you, everyone who's here so far. We really appreciate you taking the time to join today. This is an event about navigating a layoff in the tech industry in California. We are excited to share information about your rights. Just to get started, my name is Tim Newman, and I'm Tech Equity's Senior Vice President of Labor Programs. I'm thrilled to be with you all today. We're really honored to be joined by three wonderful panelists that you'll get to hear from. There will also be opportunity for folks to submit any questions that you may have about this very important topic. Also, just wanted to start by saying a little bit about Tech Equity. We are a nonprofit organization that started in California. We work to ensure that the tech industry's growth benefits everyone, and we do that by focusing on economic equity where tech meets housing and labor. We're a hybrid organization that focuses on research and advocacy, and we hold the tech industry accountable to ensure that products and practices can do good rather than harm. As part of our work, we engage tech workers to take action to build an economy where everyone benefits from the growth that tech has created. And yeah, we'd just like to thank you all for being here for this session. We hope that no matter what experience inspired you to join this call, that you are leaving today with some concrete information that will help you and your coworkers. And we'd love to stay in touch about how we can continue to ensure that workers have the protections they need. To help create a safe space for this event today that is inclusive and respectful, we're sharing Tech Equity's code of conduct in the chat. This can also be found on our website on the footer of almost any page on our site. This session is going to be recorded. We will then post the recording on Tech Equity's website. Just wanted to note, especially for folks who might have questions they'd like to submit, we'll not be sharing names of participants publicly at all. And we won't read off your names in the recording. So none of that will be publicly available in the materials that are presented after the webinar tonight. So with that, feel free to use the Q&A feature within Zoom to add any questions that you may have, and we'll have plenty of time at the end of the session tonight for folks to ask questions that you may have and to hear some responses from our panelists. And on that note, very excited to introduce the folks who are with us today. We'll start with introductions happening now. Then we'll do a presentation on knowing your rights. We'll hear from the experience of a worker who's experienced a layoff and some organizing efforts related to that. And then again, we'll have a Q&A. So our panelists today, I'm very happy to introduce Christina Lee, who's a partner at the Clarkson law firm, along with Zarrina Ozari, who's a senior associate attorney at Clarkson law firm, and Michelle Fiesta, who is a UX researcher who has experienced firsthand the impact of layoffs. And again, I'm Tim Newman from Tech Equity. So yeah, thank you so much to all of our panelists for joining, and I will now pass it off to Christina.
Hi, everyone. I wanted to start off first by saying thank you, Tim, for the introduction. And thank you to Tech Equity for allowing Clarkson Law Firm to collaborate with Tech Equity today and providing this webinar. Mass layoffs are obviously a real and common threat in today's local economy. So this is something that is, happening now. I will just tell you, just by scrolling through my social media this morning, I was reading about how Meta just went through a mass layoff, with some departments this morning. I think I saw something, the week before on a mass layoff. And so we at Clarkson believe that it's really important to inform people so they know of their rights. And so you are prepared in case something like, a mass layoff happens. And so we are more than happy to volunteer and, take part in these, informational outreach events. I'm going to go and jump into our presentation. And so what I wanted to start off with is a discussion over what is an employee and what is a contractor, an independent contractor in the state of California. Why this is so important is because whether you are one or the other, the rights that you have when a mass layoff happens is different. So I'm going to start off by talking about what an employee is in California. Basically, it's someone who performs services for an employer and is under the employer's control regarding performance of work. An employee would be entitled to certain benefits. They would be subject to certain protections under state and federal laws. And then also, they would be subject to state and federal taxes that are paid by the employer. Okay, so in contrast to that, we have independent contractors. You could be working for a company as an independent contractor. Typically, this is a person who provides services under specified terms. They are free from the control and direction of the hiring entity. And typically, the independent contractor does not receive benefits, and they do not receive the benefit of protections from certain state and federal laws like an employee would. And generally, this person would have to pay their own taxes. Okay, so that's kind of like, the main differences. So in California, there is a test that is used to determine whether a person is appropriately classified as an employee or not. I'm not going to go through these tests in detail, but the primary test is called the ABC test, and it lists the different requirements here. And so I'm not going to go through this in detail, but in case you have any questions, whether you are properly classified as an employee or independent contractor, feel free to reach out to us or speak to an attorney about your classification. Because like I said, the rights that you have will be different whether you are considered an employee or a contractor. One thing we wanted to mention that would be relevant to many of you is you may be a remote worker. So if you are a remote worker, when does California law apply? So let's take a look at these two columns here. So for California-based employees, let me start off at the top. It says California laws generally apply to California-based employees and those with significant connections to the state of California. So an example of a California-based employee are people who primarily work in or reside in California. They have a home office in California. A location where the employee was initially hired was California, where most of the work duties are performed in California. Typically, the test is they should be performing 50%, like greater than 50% of their work in California. And then the source of direction and supervision is primarily from California. For non-California based employment, it says lack of regular travel to California for work purposes, payroll and tax withholding for a non-California state, employee's license is from another state, minimal use of any California company resources or management. If you have questions over, whether it applies to your circumstance, like I said, it may be a good idea to reach out to our office, reach out to another attorney's office to have that conversation. So here are some legal considerations regarding mass layoffs that we'd like you to keep in mind if something is looming or it's happening to you, okay? Next slide. So we're going to start off with some basics. First off, what is a layoff? The layoff is the termination of employment due to lack of work or funds, typically not related to an individual employee's performance. There's two types. There's temporary layoffs, which is where an employee expects to return after a specified period. And then there's permanent layoffs, where an employee is terminated with no expectation of rehire. So let's talk about mass layoffs in California, okay? So under the Federal WARN Act, typically a mass layoff, the standards are listed here. The company is typically 100 or more full-time employees under the Federal WARN Act. The definition would be 500 plus employees at a single site, or if it's under 500 employees, then it would be that it would be considered a mass layoff if the layoff consists of at least 33% of the workforce. And under the Federal WARN Act, 60-day notice, advance notice requirements is required. Under the California WARN Act, which is broader, it applies to employers with 75 or more employees. It covers layoffs of 50 or more employees within a 30-day period. There's no 33% threshold requirement. And then there's also a 60-day notice period similar to federal law. One thing I wanted to discuss is the point of the WARN notice is to give people and the community, local community, notice of the layoff. It's to give the people affected, which would be the actual employees themselves, or even just the community in general, time to prepare for this layoff, okay? It gives them time to go look for another job potentially, get themselves situated, and it just gives them time to prepare for the actual layoff. Next slide. So some potential reasons for these layoffs is, it could be due to overexpansion. So the company is laying off people to readjust, due to market conditions. It could be a shift in investor focus. For some, they could believe it's due to AI impact. We're not sure yet if, the layoffs right now are due to that, but there's been some discussion out there about that. And then some of it is sometimes impacted by a change in remote work. For example, certain companies out there, like I think Dell, for example, had a return to work policy. I think Amazon was discussing it, and there's been some discussion out there where they're saying, in a way, that's like an undercover layoff. So let's talk about notice requirements. These are some notice things to consider when notice is given. Number one, triggering events. Typically, it's a mass layoff. Sometimes it can be due to relocation of operations. I know, there's companies out there that may be wrapping up their locations in the US and moving overseas, for example, or termination of operations. Is this the company shutting down? Notice requirements. There has to be written notice to affected employees. The notice has to be given also to state and local officials. And people should be aware of the content of the notice. There's also under 3 exceptions to the 60-day notice. There's certain situations where the company would not be required to give notice. So, for example, physical calamity or act of war, unforeseeable business circumstances, faltering company for plant closing only. And then just to note, if the company does not handle giving notice properly, there are penalties for non-compliance. So a person can be entitled to back pay and benefits for up to 60 days. And then there could be civil penalties of up to $500 per every day of violation. And then something to note with temporary layoffs, these notices still apply if the temporary layoff exceeds 6 months. So now I'm going to pass the baton over to my colleague, Zarrina, and she will be talking about severance agreements.
Thank you, Christina. Thank you everyone for participating, and thanks again, Tim, for organizing this webinar. I'll start off by discussing severance agreements. So in exchange for severance pay, some employers may offer to an employee to sign a severance agreement. A severance agreement is essentially a contract between an employee and an employer by which the employee agrees to release certain claims against the employer in exchange for payment. So as a general matter, employers are not legally required to offer severance during layoffs, but there are certain exceptions to this rule. Some employees may be entitled to severance pay under a contract with their employer. For example, if an offer letter explicitly provides that an employee would be offered severance in the event of termination or layoffs, this provision becomes legally binding once the employee accepts an offer letter and signs it. Another exception to this rule is if an employer has a policy or practice of providing severance to its employees, the employer must provide it to you if you comply with the requirements of the policy. Basically, if everyone is offered severance upon layoffs, then you should be entitled to it as well, provided that you meet the requirements. If offered severance, as a general rule, I usually advise people not to sign it right away. Take your time, review it, see if you can negotiate your severance pay. It is possible in terms of negotiating. Some employees prefer to talk to an attorney beforehand, and I always advise to talk to an attorney and see if you can negotiate or review your rights and see how much are you giving up on. So pay attention to any continuation of your benefits in the severance agreement. If an employer is committed to giving you a positive or neutral reference, this is especially important in cases of termination. You want to make sure that there is a provision where an employer would agree to provide a neutral reference to your future employers. Again, talk to an attorney before signing a severance, because a severance agreement is not only about getting money, but it's also about giving up certain rights. So before you sign the severance agreement, make sure you understand what rights are being given up. Typical severance provisions. So the provisions that we usually see in a severance agreement involve severance pay, meaning how much the employer is willing to pay you, continuation of health benefits of COBRA, and release. The most important one is the release of claims against an employer. What do you do if an employer fails to pay your severance? So assuming there is a time for an employer to pay your severance and you did not get your check. There are 2 avenues an employee can follow to enforce this. If severance is subject to ERISA, an employee must first exhaust administrative remedies by timely appealing a claim denial within 60 days and then filing suit if appeal is denied. Then the question is my severance agreement covered by ERISA? ERISA regulations apply to comprehensive severance plan that involve ongoing administration. meaning that the employer will be paying you your severance pay over time. So if an employer offers you a one-time payment of a year's salary, ERISA does not apply to you. So if the severance agreement is not ERISA regulated, claims for benefits can be filed with the Division of Labor Standard Enforcement or in court, including Court of Claims, small claims. Effect of severance pay on unemployment insurance. So to receive unemployment insurance, an employee must show that he or she is no longer receiving income. Severance pay is usually not considered wages, meaning it's not considered to be your income for purposes of unemployment insurance. But if an employer terminates an employee and continues to pay their wages, these payments may be considered in lieu of notice pay or wage continuation pay, such that the claimant is not eligible to receive unemployment for the period covered by the payment. Release of claims. So as a general rule, with a few exceptions, severance contracts releasing claims, even unknown claims, are enforceable. So there are two types of claim release. First is general release, where an employee agrees to release all known or suspected claims by an employee. And there is a specific release where you specify the claims that are going to be waived, which can also include unknown claims. But the employee knows that unknown claims are being waived and intended to be waived by them. Meaning, for example, if an employer says, you waive all age or discrimination related claims against me, including unknown claims. So these are the specific releases. Next slide. Actually, can we just go back for a second? Okay, so what claims cannot be waived? Meaning, what should not be included in the severance agreement to be waived as a claim by an employee? Workers' compensation claims cannot be waived. Minimum wage or overtime claims, meaning that employer cannot put any conditions on the payment of undisputed wages that are due to an employee. So if you worked your time and you're paid, for example, hourly, an employer cannot say, I will only pay your severance if you, I will only pay your hours if you sign the severance agreement. The other claims that cannot be waived involve unemployment insurance claims. Time to consider. Usually there is no specific time that an employee must be allowed to consider or reject the severance agreement. But if asked to release age claims, an employee must be given 21 days to consider the agreement and 7 days to recover their acceptance after they sign the contract. The age claims relate to employees who are 40 years old or older, and the 7-day provision relates to the time when you can reject the agreement after you signed it. An important thing to consider when signing a severance agreement is whether or not you have any potential claims against the employer, because once you sign the severance agreement, you effectively give up on those claims. The claims that you should consider, whether or not you're willing to give up, include discrimination claims, such as age, religion, disability, sexual orientation, pregnancy, harassment, including hostile work environment, retaliation, wage and hour, and whistleblower protection, as well as everything else listed on the slide. So make sure you talk to an attorney and confirm that you have no potential claims against your employer before you sign the severance agreement. I'm going to flip the mic back to my colleague, Christina, to discuss the unemployment benefits.
Thank you, Zarrina. Okay, so we're going to talk about, let's say, you are part of a mass layoff and now, you're no longer employed. What can you do at this point? So let's talk about unemployment insurance and eligibility for it. So in California, laid off workers are typically eligible for benefits if a layoff was not their fault. They meet California's specific eligibility requirements, and I will go through those more in a bit. They are actively seeking new employment. They file a claim with the California EDD. And then just to note, California has some of the most worker-friendly unemployment laws, but everything depends on eligibility and whether you comply with, the requirements and regulations. So just keeping it on the screen, I just wanted to go through some more of the eligibility requirements. Just know for you to be eligible also for unemployment insurance, just know for past earnings, you must have earned enough wages during the base period. Typically that's like, it's a little bit complicated. So actually I shouldn't go through it. It's kind of complicated and depends on the person. Unemployment reason, you must have been unemployed through no fault of your own. Ability to work, you must be physically able to work. Availability, you must be available for work. And then you must also be actively looking for work. And then just as a reminder, in order to, obtain unemployment benefits, you must file a claim through the EDD. There's a website, you can go to the EDD website, or you can also call in. They have a toll-free number, or else you can also submit your application by mail. You have to register through a system called CalJobs, where you can create a resume. This is for them encouraging you to look for other jobs. Just note that there is a 1 week waiting period. And then you should receive your EDD materials once you've done all of this. You'll have to certify every 2 weeks for benefits. And then typically they will send you a benefits payment card. It's like a little credit card thing where they put the payments into, and you use it like a debit card. And then just you have to make sure in order to continue receiving benefits, you have to certify biweekly. You have to, actively seek work and be available and able to work. Sometimes the EDD may require you to attend interviews, and then they may also require you to report certain information about your income. So that's a little bit on unemployment insurance and how to get it, how to get the benefits, how to apply for the benefits. So some other considerations that you may need to think about if you are part of a mass layoff is what's happening with your health insurance. The duration of company provided insurance coverage after a layoff can vary depending on company policy and employment agreements. Typically, coverage ends on the last day of the month in which the employment terminates. Some companies may offer extended coverage for a short period. Example, 30 days after termination. I find sometimes, depending on your circumstance, you can request that your company extend it. So just don't, accept what they have to offer. Sometimes you can ask for a longer time period. Employees should check their specific employment contract or company policy for details on post-termination coverage. One thing to note after you leave a company too is there's COBRA continuation coverage. You should receive a notice from your employer after you leave that you may be eligible to continue your employer-sponsored health insurance up to 18 months, but you'll have to pay the premium, the full premium for it. And then in case you need, medical insurance, you can check out what Covered California has to offer. So other than health insurance, some other considerations are think about whether you have accrued vacation or PTO. California requires employers to pay out any unused accrued vacation time upon termination. Take a look at if you have any 401k or retirement plans. Review rollover options, withdrawal penalties, vesting impacts, loan possibilities, decision deadlines, and associated fees. Stock options or equity. Review your stock option agreement to understand vesting schedules and exercise periods post-termination. Something to note with your final paycheck. In California, if you're laid off, you're entitled to receive your final paycheck immediately, including all wages owed at the time of termination. If they don't give you your final paycheck on time, you may be entitled to additional penalties. So if that happens, I suggest reaching out to an attorney and discussing what your rights are under those circumstances. Continuation of other benefits. Check if you have any other benefits, such as other types of insurance, disability insurance, and potentially discuss converting those individual policy, converting those to individual policies if you need them. And then I just put 6 just in case anything else comes up. So before I end, I wanted to go over one other thing that I don't have a slide for, but I think it'd be worthy to go over. So I mentioned earlier, you know, the rights are typically different for an employee versus a contractor, okay? A lot of what I just went through with respect to the benefits, those are things that would apply to an employee who receives benefits through a company. But if you're an independent contractor, you know, what can you do here? So let me just go through just a short list of what an independent contractor's rights may be if they are part of a layoff. Typically, the rights are governed, the rights of an independent contractor are governed by their contract with the company, right? So a person, if they are laid off and they are a independent contractor, the first thing I would point to is look at your contract and see what it says with respect to, you know, early termination of a contract, for example. Even if your contract is terminated, just know that you are still, as a contractor, entitled to be paid for all work that you have already completed under the contract, even though the contract is terminated early, okay? So just know you still have the right to your wages that you've earned under your contract. And then something to keep in mind too, I mentioned before, you may have additional rights if you are an independent contractor, but you are truly an employee because you were misclassified. I mentioned there's the ABC test earlier. If you think that's something that may impact you, as I mentioned before, reach out to a law firm, reach out to our office and have that discussion on, you know, whether you may have been misclassified or not. And then just know too that even though you are an independent contractor, you may still be, you know, you are still likely protected from such things such as like discrimination, okay? So if there's something, you know, where you believe that there was some sort of discrimination impacting your, you know, the termination of your contract, then, you know, I also suggest that you speak with an attorney about your potential rights in that circumstance. And that ends my presentation. I'm going to pass it to Michelle now.
Yes, wonderful. Thank you. And then just wanted to share a quick reminder that folks can use the Q&A feature within Zoom if you have questions. And after Michelle shares her perspective, we'll get into some of these questions. And I also just wanted to share a quick reminder that This webinar is to provide information for educational purposes only and does not constitute legal advice, of course. So on that note, I also forgot to mention that Christina also goes by Tina, by the way. And on that note, we will pass it to Michelle, who will share more about her perspective as a worker who has experienced some of this firsthand.
All right. Hi, everyone. My name is Michelle Fiesta. I'm a user experience researcher. I've been in the tech industry for about 8 years now, a little over. I've been in enterprise as well as startup and worked in a bunch of different industries. I've been in ed tech and fintech, SaaS, and now civic tech. Unfortunately, like many of us, I experienced a layoff in the summer. Actually, in the summer of 2022, I survived a layoff. And then about 6 months later, unfortunately, I was impacted by one. I took some time off, but as I was sort of navigating the layoff journey, I realized that there was actually not that many resources available, especially in terms of like the non-legal stuff. Like, I think I found a lot about, unemployment and healthcare, but not so much about the actual experience of going through that and navigating that and figuring out how to apply for benefits, how to use them. I think Tina mentioned earlier, there's like a card you get. I found that it was actually really difficult to use, but I didn't find a lot of like community or resources about it. So I went hunting and I discovered the Tech Workers Coalition. They're a coalition of workers in and around the tech industry. There's also labor organizers and community organizers involved. And that's actually how I found Tech Equity as well, and this lovely group. So I'm actually in the process of kind of figuring out a way to create the thing that I didn't find. I'm a user experience person through and through. So I'm developing a tech worker layoff guide and hoping to include things like how to apply for unemployment benefits and use them, how to navigate the healthcare process from like a non-legal, more human approach. Also including things like free and affordable job seeking support, like where I'm going and have gone for that. I know that money is tight for a lot of folks, especially if you've been laid off for 6 months, 12 months, 18 months in some cases or more. So having that access to that kind of thing is super important, as well as just community and finding ways to chat with people that are in the same boat. It's a very human experience and a very tough one to go through a layoff, and especially the potentially long length of time not having a job. So finding ways to connect people, essentially. That is all in progress. So if you're interested, I'm definitely soliciting, the more the merrier for this type of thing. I'm not the one end all be all of all of that kind of information. So if you're interested in either supporting that or even just giving feedback, like, hey, I would love if a resource like this included, XYZ, feel free to either join the Tech Workers Coalition Slack. I created a layoffs channel in there where you can chat about it and also just meet other people that are affected. Or you can reach out to me directly if you don't want to join the Slack. So super happy to be connected, even if it's just to chat about the experience, happy to do that. Or if you want to support this effort.
Okay, can you hear me now? Is that okay? Okay, great. Okay, everyone can hear me. Okay. Wonderful. So we will be going through some of the wonderful questions that have been submitted through the Zoom feature, but I did just want to kick things off with, we did receive some questions in advance. I'm going to start off with one that's a big question, and I'd love to hear your thoughts on this. So the question is, what are the possibilities of making the unemployment system more generous, less punitive, and more suited to the modern economy? So curious,
I have some
that's a big
comments on
one.
that. Because
Yeah,
I
let's
looked
hear it.
into this, and people have been trying for years to make changes with the unemployment insurance circumstances in the state of California, but it's so slow moving, it's ridiculous. Like, they're saying how the amounts that people are receiving have been the same for like the past 2 decades. So that hasn't even increased, even though the cost of living in this state has, right? So unfortunately, even though, it would be nice if they did make improvements in it, we're just finding that it's slower than a snail. It's there's been rarely any changes that have been made over like the past like 2 decades in this area, unfortunately.
Hmm. Michelle, I'm curious, just because that's been one of your experiences too, I was curious if you have any thoughts on ways that this could be better or yeah, anything like that.
Yeah, I was just typing an answer to somebody that asked about this in the chat as well. That's something that
Wonderful.
I'm also personally interested in. I'm starting
Mhm.
with resources because it seems like the thing that would be most impactful to the most people the most quickly. But also obviously policy change and finding ways to affect like the law and how things are going right now, I think is also a big deal. I think, you know, tech workers community, we have such a wealth of skills and knowledge and ability to make change like this happen. It just needs to be organized. So I would encourage joining the Tech Workers Coalition. It's a great place to meet folks that are interested in doing this type of work and to share your ideas as well.
Awesome. And then there are definitely questions about this topic of severance agreements. So I would love to hear your thoughts on how your average worker experiencing a layoff can find leverage to be able to negotiate as good a severance agreement as possible. And maybe if you also have some examples of specific things to look out for, like more severance pay, extended benefits, keeping a sign-on bonus, or additional items that may not be commonly reflected in severance agreements. Any thoughts on this one?
I can provide some thoughts. So as a general matter, as I mentioned in my presentation, employers are not required to provide severance contracts. So if there is one provided, you can try to negotiate, and the leverage that you might have will depend on each individual's situation. For example, if you feel like you have a potential claim against your employer based on discrimination, and you're willing to waive that claim in return for more money, then you can reach out to your employer and see if they're willing to increase your pay. Usually I would recommend involving an attorney to engage in those negotiations. In my experience, in my practice, a lot of times employees will come to me and say, I tried to negotiate myself and the employer increased it by $2,000. I'm not happy with it. Can you do something? And then we step in, and then the employer increases the amount by 20,000 or 15,000. So a lot more than was originally offered. Obviously, if an employer is involved, if an attorney is involved, an employer acts differently. But you can always try to talk to an employer. Usually, when you negotiate coverage, insurance coverage like COBRA, most employers are open to extending it by additional month or two. Obviously, it will be a lot harder if you ask for a year or two of coverage. But yeah, that's my take on it. Try to negotiate, do it in a very soft way, not hostile, because again, employers are not required to provide you with severance, and you don't want them to withdraw it once the time is up.
Great. Okay, cool. You know, one piece of, I'm just going to skip to a question that was submitted ahead, which is kind of related to this leverage question. There's someone who had asked, what advice would you give to staff who want to advocate for people who might be impacted? So I think what this is getting at is like people who are at a company where there's been a mass layoff, they may not be affected. Do you have advice? This might get into a general know your rights in terms of workplace organizing kind of question, but I'm curious if folks have any thoughts on what employees who may not be impacted by a layoff, what they should know if they want to speak out and do things to support people who are impacted by a layoff. Any advice you may have there?
So wait, the question was, sorry.
It's the question is, what advice would you give to staff who want to advocate for people who might be impacted? So I think the assumption here is someone who's still at the company when there's going to be a mass layoff to maybe apply and be part of the leverage to help workers get a better agreement.
I think it's a little bit challenging to join someone else's layoff, right? If you're not impacted. But if you feel like the layoff was illegal, and mass layoffs or just layoffs in general could also be illegal. For example, if an employer decides to lay off all women from a company or all their employees, right? Even if it's a layoff, it could be discriminatory. And then you observe this fact and you try to advocate for it, right? And complain to HR, let them know that this is an illegal activity that's going on, then you should certainly do so. And there are certain laws that protect you against retaliation by an employer. So if you face retaliation after you complain, that talk to an attorney. You have a claim for retaliation. Does that answer the question? Christina, you have something to add?
Christina.
Oh, yeah, I was going to add, I think maybe I was like not understanding the question properly, but
Okay.
I guess some other thoughts that I have is if you're advocating for other people that may become part of a mass layoff for your company. Some companies, what I'm seeing is they, instead of giving the 60-day notice, they give them even a longer time period, right? So that gives a person even more time to prepare. So what I guess I could do if I was working at a company and I was concerned about my employees and their circumstances is I've seen some companies give people like a year notice, 6 months notice, you know, before something happens. So it gives them enough time to go and find another job. Or you could advocate for your colleagues to have larger packages. I mean, I know some people who, you know, receive some pretty nice packages where, you know, they got severance for like a year. So where are they now? Like taking vacation for a year, right? So, I mean, there's things like that that can improve a situation, right? And, you know, some things could be like encouraging the company to hold off on giving notice so the person's there longer, or don't do it around the holidays, you know, like there's like reasonable things that can be advocated for on behalf of your co-employees so it doesn't really hit us hard.
Great.
So, and I think sometimes there's circumstances other than, you know, people being laid off in their position. Sometimes there's the ability to also look for other positions within the company. So that's something that could be a potential as well.
Yep. This is an interesting one that I think comes up fairly frequently in this industry. So someone said they're a worker in California on an H-1B visa who just got laid off. What can I do to stay in the country? This may or may not be your area of expertise in the law, but I'm curious if you have thoughts on people who are on visas.
I think this question will be more appropriate for an immigration attorney.
Okay.
Unless
Yep.
Tina has some thoughts, I don't think we can provide any information on that.
Yeah, that unfortunately is not my expertise either. But you know, I you know, if the person wants to reach out to us, I think we can find someone to refer them to. Okay,
so if that was your question, hopefully you can follow up and get some more help and information that will be helpful to you. Okay, this might be a little specific, but the question is, can the employer lay you off prior to 401k vesting coming to fruition? For example, at 11 or 12 months, if that happens, what can you do? This may be too specific, but if you have thoughts on this.
Yeah, I'll speak to that generally, just generally speaking. It, you know, for most employees, they have an at-will employment situation with their employers. So they could be fired at any time, terminated at any time for any reason that's not a legal reason, right? And vesting is not something that I think, you know, companies are really that concerned by. And so, you know, my overall thought is just generally speaking, they could terminate you at any time unless it's, you know, they can't do it for an illegal reason. One thing you could do if that circumstance does happen, and like maybe you're so close, right? Is if you are being terminated, see if you can negotiate something with the company. You know, usually when you leave a company, companies nowadays like to have people sign off on a release, so you never come back and sue them for whatever reason, right? So if that happens, or even if it doesn't happen, I would say try to negotiate it with the company and see, what they're willing to do.
And
Mhm.
just to add to it, great point, Tina. The only situation where I see that to be a breach is when it was explicitly discussed in your offer letter that they will not terminate you until a certain date, and they do, then it's a breach. Other than that, as Tina noted, it's going to be a hard thing to prove.
Mhm. Gotcha. And then when you were talking about severance agreements and releasing claims, some of the language is around unknown claims. Could you say a little bit more about what that means exactly?
Yeah,
folks?
so
Yeah.
so the known claims are the ones where you certainly know that an employer violated your rights, right? Or the employer wants you to waive a claim for age discrimination, given that you are 60 years old and you are being laid off, right? An employer explicitly says you're waiving any potential claims related to age discrimination in the future. But then the employer can include unknown claims, meaning, let's say, hypothetically, down the road, you discover that you were a part of a layoff where all women were laid off. And so you have a potential gender claim, but you didn't know that at the time. So you sign the severance, you release all known and unknown claims. And so later, when you discover that you were involved as a female in this gender-based layoff, you cannot bring that claim anymore because you waived unknown claim. That's going to be considered as an unknown claim.
Okay. And then we had a question that was like, so in this example, if you suspect that your layoff was based in discrimination, how would you recommend someone proceed? And also just, a lot of the recommendations have been, depending on your case, you may want to consult with an attorney. Do you have also just general ideas of where is a good place to go for folks to find labor attorneys in California who may be able to answer questions?
Yeah, I'm part of a group called the California Employment Lawyers Association, which Zarrina and I are part of. And so if you check out that organization, there's employment attorneys from all over the state that are listed on that website. You can feel free to reach out to our office, Clarkson Law Firm, Zarrina and myself. We're more than willing to talk to anyone if they have any questions. If we're unable to help you, we also both know many attorneys, employment attorneys that specialize in different areas too, that we could refer you to as well. There's also, your local bar association, depending on where you're located. So like, for example, I live in Los Angeles and I'm part of the Los Angeles County Bar Association, right? Every city has kind of like their own bar association. If you look at that bar association's website, you'll be able to find employment attorneys listed with them as well. So we're in a state where there's very friendly employee protective laws. So there's also a lot of employment attorneys. So don't worry. You will be able to find someone.
And Tina, I know that a lot of folks will have questions about cost. I know that especially in a layoff situation, you might not have necessarily a lot of funds that are extra. So could you talk a little bit about what that would look like?
Yeah. So the fee situation is really dependent on the person's circumstances and how strong their claims are, right? A lot of times if we're taking on a case for a plaintiff, if it's a strong case and depending on the type of case, we may take it on a contingency fee basis, which means, the employee and the client would not have to pay any fees or costs relating to our representation. However, whatever recovery is received, we would get a percentage of it. Okay. Also, other types of like fee situations could be, maybe, they just want someone to review their severance agreement to see if there's any issues with it, right? And we're not really negotiating them out. They just want to see if, everything in it looks good. Then in that circumstance, an attorney may be retained on an hourly fee basis, right? So it really depends on the circumstances and like what the person's needs are.
We are nearing the end of our hour, unfortunately. So I wanted to take just a couple. I know there are some additional questions, so please feel free to continue to reach out to us, and hopefully we can get you some answers to this. And then I think also what Christina and Michelle shared about other resources is a great next step for folks if you feel like you still have questions or things you want to discuss. Just wanted to thank everyone for attending and for participating in this. I know that this topic can be very stressful to discuss, and so that's why it's so important to know what protections are in place and where to go for questions and resources if you or folks you know are experiencing this. Again, this webinar has been recorded and will be posted on the Tech Equity website. So as a registered participant, you'll get a link to that, and feel free to just check out our website in the next week or so, and feel free to share this with folks who might benefit from this information as well. We also are hoping that this will be an ongoing series. So if there are other topics that would be of interest for you, please definitely reach out to Tech Equity and let us know what topics you'd like to hear more about. And then also, ideally, like we've talked a bit about protections that do exist, but as many of the questions indicated, there's plenty more that we could be doing to protect worker rights. So if you want to get involved in advocating for better protections, for even more of a safety net for folks who are experiencing this, please reach out to Tech Equity, reach out to Michelle, as she mentioned, and Tech Worker Coalition, other organizations to get more involved. We'd love to hear from folks about how Tech Equity can be a support to folks who want to advocate for better conditions. And then, yeah, just make sure that you sign up for our email list in general to hear about future opportunities in the coming weeks. And then to our panelists, if there's anything you'd like to plug or any final comments you'd like to share, I'd love to turn the floor over to you as well. If there's anything, no pressure.
Sure. Can everyone, well, you can hear me. I just wanted to say thank you once again to Tech Equity and for setting this up. This was a fantastic webinar. And like I said, I think it's really important for workers to know what their rights are, so they're prepared to address situations for themselves or to help friends and family, for example, right? Clarkson law firm, we do have our employment department, which I'm part of, along with Zarrina. So our contact information is here in case anyone wants to ping us for any sort of question. Something that's interesting too, I'll just point you to our website, clarksonlawfirm.com. We are a consumer, I'll say this, we are a private public interest firm, and we advocate on behalf of the rights of consumers and employees in the state of California, and other, victims of other, issues out there in the environment, with products, with different things. We like to advocate for all different issues. If you have any questions, feel free to reach out to us.
Wonderful. Michelle, any final thoughts or comments?
Yeah, also thank you for joining, and I'm sorry if you joined because you've been impacted by a layoff. I totally understand. It's not the best thing ever. I would say definitely if you're feeling like you want to do something about it and take action, please join Tech Workers Coalition or reach out to me. I'm not an organizer. I haven't ever been one in the past. Maybe I'll claim the title soon, but I think it's something that you can do even if you haven't ever done it before. So feel free to jump right in, and you have the skills and you have the ability. So
look
great
who's
point.
here.
Yeah,
And we have a
no
guest.
better time. No
She
better time to
came
get started.
back.
Also, on that note, I think it's time that everyone go take a walk after getting so much great information. Thank you again, once again, for joining. And yeah, have a great evening
Thanks,
to you
everyone.
all. Thank you so much.